Speaker, and I commend this bill to the House.
Andrew Williams.
Thank you, Mr. Speaker. I take a call on behalf of New Zealand First in the Construction Contracts and Amendment Bill. We will be supporting this through to Select Committee. We do see merit in some aspects of the bill. However, we do have some reservations in others. It's certainly where it says amendments will remove most of the distinctions between how the Act applies to residential and commercial construction contracts is, we believe, sensible, because there are some grey areas between the residential and commercial construction sector, and often there are loopholes there that could be closed up. It also does widen the definition of construction work to include the design, the engineering and the quantity surveying work. And again, often there are those other contract elements of any construction project that perhaps are not necessarily deemed to be part of the project, however provide a vital component in a good outcome of the particular construction in question. And therefore we do believe that has merit too, to include the design and quantity surveying. Mr. Speaker, it also mentions here that it would reduce the amount of time a defendant has to oppose an application to have a determination entered as a judgment. And I guess in some respects we have some reservations about that, because whether reducing from 15 days to 5 days is a good thing, it does perhaps limit the opportunity to a proper defence and to have proper legal advice on the matter, and perhaps to have the correct professionals be able to have input into it. That will be something, I guess, will be fleshed out at the committee level, and we will have an opportunity to see whether that is a practical, workable solution, reducing that to 5 days. The requirement for adjudicators to convene a pre-adjudication conference is a good thing in many of these areas. If it can be worked through pre-adjudication meetings and conferences before it gets into the thick of legal wranglings, then that is very positive. And certainly in many areas, and indeed with other acts such as the RMA and other areas of the Local Government Act and various things, if there can be pre-adjudication conferences, often some of the problems can go away before it actually gets into the final negotiations. In this respect, we also would like to see perhaps considered in all this, and perhaps we will be putting up an SOP in this regard at a later date, but we believe it is time that New Zealand did have a proper construction bond system, and perhaps that would be one way of working through this, which does occur in many other jurisdictions around the world, where there is a requirement for a performance bond. And in terms of that, a performance bond is a surety bond issued by either an insurance company or a bank to guarantee satisfactory completion of a project by a contractor. And perhaps that would be a good way through, so that you don't have the situation as has occurred in recent past, where people register a company and it's Joe Bloggs 2010 Limited, and as soon as the project is finished, Joe Bloggs 2010 Limited is wound up, and they move on to Joe Bloggs 2011 Limited. And then nobody can actually find the original company to go after. Perhaps if there was a system which included performance bonds which are tied directly back to the directors and to those who have signed the bonds, there might be perhaps more certainty in the market, and we would not have some of the cowboy activities that has been seen in years gone by. And that particularly relates to many instances with leaky buildings and leaky homes, where now the last man standing often tends to be the local authority and council, because simply the original builders can no longer be found or no longer are in business under that particular name when they built the building. I also note that in this Construction Contracts Amendment Bill, there will be a new Section 31 will also prohibit charging orders where a construction site is owned by a family trust and occupied by a beneficiary of the trust. That is an interesting one, and I think in recent times it's been noted that the large mansion being built by the Hodgsons on Paratai Drive in Auckland, I understand, is under some form of trust arrangement. And again, there's been great difficulties in many of the contractors and others perhaps completing the work there and completing payment because it's been done through other mechanisms and through other trust mechanisms. And now the trustees themselves are trying to get money out of the trust to the tune of very significant amounts and hiding behind that particular guise. Therefore, if this bill does include making it making it more difficult for people to have some of these smoke and mirrors trusts to hide behind in terms of construction projects, then that would also be a good thing. So, Mr. Speaker, New Zealand First sees a great deal of merit in this. This tidies up aspects of the original 2002 Construction Contracts Act. It received quite a bit of input over the last year or so while they did draw up this amendment bill. It has had significant input from all sorts of sources. There is some very good merit in many aspects of it. New Zealand First will support it through to the committee stage, and we hope as a result we will get some good legislation coming out of this.
Thank you. I call the honourable member, Colin